Yesterday's proceedings, the defense made certain disclosures to the prosecution pertaining to certain witnesses who were mentioned and or alluded to during the course of the defense opening statement. And the prosecution asked for leave to, actually at the court's suggestion, the prosecution accepted leave of the court to evaluate the significance of that disclosure and to report back to the court this morning. And so the record is also clear. Yesterday evening at approximately 10:30 in the evening, I received a phone call from the Assistant District Attorney Frank Sunstead at my home advising me of the sudden illness of Mr. Hodgman, who was the Deputy District Attorney assigned or who was handling the discovery issue and the objections to the opening statement by Mr. Cochran. Ms. Clark, what is the position of the people this morning?
Your Honor, at the court's direction last night, we attempted to go and evaluate what exactly had occurred in court and attempted to address the egregious issues of misconduct. We were working until approximately 1:30 in the morning, and we were doing so without the benefit of the assistance of Mr. Hodgman, who was taken to the hospital at I believe approximately 6 p.m., which did hamper our preparation. We are going to be ready to address the issues that were raised by the conduct of counsel. If we could have an additional period of time until 1:30 this afternoon, we will have something in writing for the court addressing each of the issues of misconduct committed by counsel. And we did attempt to have it ready for the court this morning, but having worked until 1:30 in the morning last night, we simply could not complete it in time.
All right, assuming the prosecution's written objections are submitted to the court today at 1:30, what is your position as far as continuing the opening statements and proceeding in the absence of Mr. Hodgman?
That will depend on the court's ruling on our motion, Your Honor. And when we said we will be requesting certain things of the court, and depending on the court's decision with respect to those requests in our moving papers, then we will know what our position is in that regard.
All right, are you in a position to tell me what remedies you're going to be seeking?
Not at this time, Your Honor. That's being prepared as we speak. We did an exhaustive search through the record, among other things, so the court will know how some of our time was taken up. We did an exhaustive search through the records for all of the representations of defense counsel concerning their compliance with discovery orders, and there were numerous representations by the defense of full and complete disclosure, which have, of course, been proven to be false. And we had to cite those to the court, as well as the numerous letters that we have sent to the defense, which were not answered in a truthful manner, as well as the court orders that were issued, which were willfully violated by the defense. So we have had to compile quite a bit of material to demonstrate to the court the misconduct of the defense, in addition, of course, to the most recent.
I have to tell you, what I'm interested in is knowing what the prosecution's position will be with regards to each of the individual items that objection was made to, each of the witnesses that were disclosed in the last few days, and the line of argument or defense that was objected to, or the evidence that was objected to. I need to know what the people's position is with regards to each one of those discrete items. Because each is different, each has a different date of disclosure, and each has different relevance to the case, some of which is hard for the court to evaluate. Can you give me perhaps a explanation under what scenario, under what set of circumstances the prosecution would be willing to go forward and complete the opening statements today?
Well, I appreciate the court's direction, number one, as to what the court desires with respect to each witness and the representations made in argument. That in order to address it in that kind of specificity, though, we're going to need to address the court with more than one lawyer, because we have our lawyers working on separate areas. And ordinarily, in order to comply with the one-lawyer rule, we would have all of them funnel their information to one. If the court would like us to respond with that specificity, we would ask leave of the court to have an exception to the rule, because there's no way that we can be ready with one lawyer to present all of that at 1:30. Either that or to allow us a little additional time. But with respect to each witness or groups of witnesses, there will be, the court, I understand what the court is saying. There is a difference in the nature of the sanction. I do appreciate that, Your Honor.
Well, what I'm asking is, since I have a jury, there was a very practical reason for my question. I've got a jury in the waiting room right now, sitting there, and I'm just, if there's any point to keeping them here, what is the set of circumstances that you would be willing to go forward with the opening statements and conclude at least Mr. Cochran's opening statement?
May I have a moment, Your Honor?
Sure. Ms. Clark.
Yes, Your Honor. Thank you. The sanctions that we will be requesting will be admonitions to the jury with respect to some witnesses, preclusion with respect to others, and we need a consensus among us as to which sanction for which witnesses. That's why it's difficult to address the court, I understand. Right. There also will be issues of continuance required in order to address the new discovery, as well as the request to reopen the people's opening statement in response to the arguments posed by counsel.
All right.
And I appreciate the court's position. It needs to know what to do with the jury. These issues are going to take a little while to resolve, but depending on the court's ruling with that, on those various issues, we would have no problem with the resumption of opening statement. But I think we need to present this to the court for resolution before we resume with the opening statement. I just don't know how long that's going to take, because we are presented with a myriad issues to address.
All right. Thank you, counsel. All right. Good morning, Mr. Cochran.
Good morning, Your Honor. Your Honor, first of all, those of us on the defense are very sorry about Mr. Hodgman's illness, and we wish him a speedy recovery. We're also representing Mr. O.J. Simpson, a man we believe is absolutely innocent, and the evidence will show that. So we have to kind of balance that. Certainly, as I indicated to the court earlier, if there is a problem with Mr. Hodgman being here, and that will cause the people some problems, we are willing to wait a couple of days on that from a standpoint of proceeding with the evidence. But, Your Honor, I need hardly remind this court with regard to opening statements that we're ready to proceed with opening statements on Tuesday afternoon after the people concluded at 3:30. And because of a glitch, which was no fault of, was an accidental glitch, but certainly no fault of Mr. Simpson's, the court took a recess at that time. We weren't able to finish our opening statements. We accepted that, like we do all the things that happened here. Finally, yesterday, I was able to make my opening statement. And I'll be very interested in their motion. As usual, they tend to be totally judgmental, talking about misconduct. There is no misconduct in this case. They can't stand the truth. I indicated that before. If counsel gets up, and if you look very closely at that opening statement I gave yesterday, and we talked about, let's say, the blood under Nicole Brown Simpson's fingernails, it's not anything they told them. So the fact they're upset, this is the same group of people who've been asking for a continuance. So this is, if a defendant had done this, asking for continuance, and then have all these things and continue to ask for continuance, everybody would be very suspicious. But here it's the prosecution who continually is doing this. So all I'm asking is, and what Mr. Simpson asked, is that we be allowed to complete the opening statement as soon as possible. It is unprecedented to have my opening statement interrupted all of these times, to have them talk about getting up, giving a further opening statement. Then do I get to rebut that? They cannot shut me up, Your Honor. I'm going to tell the truth about this case. I'm going to comply with the rules. We make a mistake, we'll talk about that. But if you look through that transcript, the things that we talked about, or things that either we disclosed to them or things that I knew about that I have no obligation to tell them about, they cannot get inside my head, and they have to might as well understand that, so that they're not going to be able to preclude me. You recall once before I said they're constantly trying to shackle me from a standpoint of addressing the issues. The court has already indicated to these jurors that what both counsels say is not evidence. And if we don't prove something, or if we fall short of that, the remedy is the jurors say, well, gee, you said you were going to do this and you didn't do that. And so that's what the remedy is. You told them how many times that it's not, opening statement is not evidence. And I noticed Ms. Clark inadvertently kept using the words argument. You'll recall that when they were giving their opening statement, making all of these outrageous, specious claims about O.J. Simpson, continuing to tarnish his reputation, we sat here and listened to that, as we have been doing for 7 years, 7 months, as they talk about all this mountain of evidence. We didn't object. We tried to conduct ourselves as professionals until the very end, when Your Honor had to ask Ms. Clark to sit down for being so argumentative. That's when those are the facts. We went through that. Yesterday, they assigned Mr. Hodgman to track my opening statement, where he objects 13 times, about 11 of which were overruled. And I told him at the time, they're not going to throw us off with that kind of tactic, Your Honor. Now they want still a further delay. So we need to put this in perspective as to what we're talking about here. We want to be able to conclude our opening statement and get to the case. Judge, as somebody wise indicated, this is the people's case. They made this judgment back on June 16th, and we called for this man's arrest on June 17th. They have the entire Los Angeles Police Department. I presume they have 8,000 persons. They have the third or fourth largest police department in this county in the district attorney's investigators. They have 900 lawyers. They said they were ready to go. They have all of that on their side, and yet they're going to come whimpering into this court and claiming they didn't know something, or their investigators didn't know something, because I have a theory in my head, or a fact in my head, about this man's physical condition, or something they didn't want to hear. And so we have to put it in perspective. And then they want to call that misconduct. It's not any misconduct at all. They've been trying cases, both of them cases for 20-some years. And I guess as Bob Philibosian said, who was a former DA, said last night, this is much ado about nothing. He said he tried cases for 20 years, as you did, and never had a report from the defense. Now they want to get in our briefcases. They like to come home with us if they could. Well, they can't do that. The law does not require that. And so all this stuff, this is much ado about nothing. Former district attorney, who's one of their groups, says that. Everybody says that, and we need to get down to it. This is a stall, Your Honor. Let me finish my opening statement. Why are they so afraid of me addressing this jury and telling them the truth? That's what this is about. And that's all I want to do, is complete my opening statement. You're the arbiter. And you know, yesterday, we were totally respectful. Every time there's an objection, we approach the bench. And when the court gives some directions, I follow those directions. I don't go beyond that. I was not nearly as argumentative as both of them were in the opening statements. Absolutely not. And Your Honor, because if I had been, you would have been calling me on it. But at the end, you had to have her sit down. So let's get to where this really is. It's not about personalities. And what this case is about is trying to get a fair trial for this man here. And he shouldn't suffer because of their tactics and their stall tactics. And that's what this boils down to. So we're ready to proceed. And quite frankly, I'd like to proceed right now, because as you've also said, and I want to end on this note, this also is about these 22 citizen volunteers. And yesterday when they came out, or the day before yesterday when they came out, you said, I hope this is the last time I'll have to apologize to you for not starting on time. And then you caught yourself and said, but I know it won't be. So now we got to apologize again today, all because of these delays. And the delays are from them. I'm ready to go. You're basically would be ready to go. They're obviously ready to go. This is their case. Now who's not ready to go? The people. Who is it who wants to continue to curtail what I can say to the jury? The people. And it's their case, Judge. As I said the other day, they don't want to hear the truth in this case. But the truth will out. And when you put it in counter position, Judge, for the last 2 or 3 weeks, they've been on a public relations campaign to tar and besmirch this man. May I finish, please? I didn't object when she was talking.
Isn't the issue here whether or not we're going to go to 130?
May I finish, Your Honor?
Isn't that the only issue before the court?
May I finish, Your Honor?
Thank you, Mr. Redden. Mr. Carkman.
Thank you very kindly, Your Honor. See, whenever I'm talking, Your Honor, they want to stop me from talking. That's a great example.
I have work to do.
Well, he can leave and go do his work.
I like a ruling so that I
Thank you.
can do this or go upstairs.
Mr. Darden, I'm
and
hearing
complete the
from
motion.
one counsel at a time. Ms. Clark is the one addressing this issue. Thank you. Mr. Carkman.
Thank you very kindly. I guess, Your Honor, nothing could be more graphic than what you just saw. That's exactly what's been happening in this case. And it's not personal between me and Mr. Darden and me and Ms. Clark. This is about our client, as I was trying to say. They went on this public relations media blitz to tar this man. Finally, Your Honor, after 7 months, yesterday, somebody spoke up for O.J. Simpson. All across this country, in the byways and highways, they heard another side, what this evidence is going to be. And they can't take it. And that's not fair. Now, what about him? I mean, if he would love to address you, but we're not going to let him. But on what it feels like to be the one who's been the object of all the things they've done to him, and they then have the temerity, the unmitigated gall to come in here and complain that, gee, they've somehow been sabotaged, and they're the one who brought the case, Your Honor. So let's get this opening statement completed. Let's get to the evidence as soon as possible. Let's try to put it in perspective, and let's conduct ourselves like lawyers. We won't be trying to interrupt them. We didn't interrupt them when they were giving their opening statements. I won't be standing up when he's talking like that. They should conduct themselves like lawyers and be professional. Let's get this done. Thank you.
All right, Mr. Carkman, let me ask you a question, though. The issue right now is whether or not we're going to trail over until 1:30 to determine what the people's position is going to be. And obviously, we're in the unusual position where Mr. Hodgman has taken ill. He's in the intensive care unit. I mean, obviously, they're entitled to some relief, if nothing else, just to regroup. Secondly, the defense did make disclosure yesterday of a number of witnesses and turned over witness statements that were dated in August and July of last year that they were not aware of. And Mr. Douglas forthrightly indicated that an error had been made in not turning those over. So the prosecution is in the situation where one of the three lead prosecutors has taken ill, is still in the hospital, and your side has conceded that it was a mistake not to turn those items over to them. They're entitled to have the opportunity to evaluate what was turned over late. They're entitled to ask this court for sanctions. They're also entitled to reevaluate their position in light of the absence of Mr. Hodgman. I'm going to give them the time until 1:30 to do that.
May I respond to that? And I started my remarks by saying, Your Honor, that I'm very sympathetic to Mr. Hodgman.
As we all are.
And we all are. I mean, he's a wonderful person, and there's no question about that. And as I said, we're very concerned about that. But, Your Honor, I want to put one thing in perspective. And when you look at that list, first of all, the list came about because,
Mr. Carkman, why don't we save the discussion about what's on the list?
All right. But I just wanted, can I just make a response to what one thing Your Honor said? Allow me, please.
Certainly.
You had indicated that on the list that there were a number of disclosures that were late. I think when you look at that list, the list came about because you had asked Mr. Douglas to make sure. Mr. Douglas only became the evidence coordinator. I can say this because he's not
Mr.
here.
Carkman, I understand that.
Right.
I understand Mr. Douglas's comments to me.
Right.
I recall them very clearly.
Okay. But what I wanted went out to the court. There are very few witnesses on that list, if any, that I alluded to in opening statement, many of whom won't even, I don't think, be called. But again, I think it was just a question.
No. I listened to one side very carefully, very patiently, then you get to respond. I'm going to grant your request till 1:30, Ms. Clark.
On that note, Your Honor, may I be excused?
No. Be seated, please.
You
Thank
want me to
you.
write the motion?
Be seated, Mr. Darden, would you please? Thank you. All right, Mr. Carkman, have you concluded your comments?
Not yet, Your Honor, if I could.
Would you please?
Okay, I will. Thank you very kindly.
This is going to be a long trial.
No. Well, I don't think so, Your Honor. If they would learn to follow your rules, I think it would not be. All I want to say, and just conclude with this, is
Well,
the same.
Mr. Carkman, don't bait them unnecessarily if you don't have to.
No, I'm not baiting them, Your Honor. I mean, they're adults, not children. Okay, but I want to bait them, Your
Do we
Honor.
have to sit here and listen to this all morning?
Mr. Darden, please. Please.
All right, Your Honor, let me conclude just by saying,
Would you be seated, sir? Thank you. Mr. Carkman.
Your Honor, we will be, the point I was just trying to make in response to Your Honor's statement, I think that you'll see when you see the witness list that very few of those witnesses were alluded to in the opening statement, that the list came about because you'd instructed us to get on top of that.
The problem is, by conceding that very few on that late disclosed list were mentioned, the fact that they're mentioned at all and lately disclosed is an issue that the prosecution is entitled to litigate.
And I understand that they want to make that issue. That's fine, Your Honor. But what I'm saying to you is that we can address that in quick order, I think. I think when you look at it, it's not as much ado about nothing, and that's the thing I wanted to point out to the court so we can get all of it. Thank you for being patient listening, Your Honor. I appreciate that very much.
All right, counsel, anything else before we recess till 1:30? Mr. Darden? I also have to take up the DNA discovery issue that Mr. Blazier and Mr. Harmon, I think, are going to address. Anything else, Mr. Darden?
Your Honor, I see that every time the jury comes in, that the defense has pictures of Mr. Simpson and their boards turned to face the jury so that they can read them as they walk through the jury box. And I'd ask that the defense be directed to turn their boards around, as we have.
That's probably true. Both sides need the court's permission before they put up any displays while the jury's in. All right, thank you, counsel. That'll be a standing.
Your Honor, it was up last night. I think they didn't take it down. And the jurors haven't seen it. They haven't been in here.
But a standing rule will be no exhibits will be displayed until the court is in session and the court has given permission for that to be posted. All right.
And on the issue of discovery, Your Honor, and I don't desire to argue the issue of discovery at this time, but I want to make the record perfectly clear, and we will show this afternoon when we discuss the issue, and that is that there were a number of people mentioned yesterday, people who are not on their witness list, people whose witness statements had never been turned over to us as they should have been, and when we objected, we got no relief. Okay. Had we known about some of these witnesses, we could have informed counsel that they are heroin addicts, thieves, felons, and that's one of these witnesses, one of their so-called material witnesses, is the only person I've ever known to be a court-certified pathological liar.
All right. Thank you, counsel. Let me, before I let you excuse you, Mr. Darden, let me also advise counsel that there is a standing order by both supervising judges in this building that no press conferences will be held on the 9th floor. Apparently, we have a misunderstanding by counsel in this case who have conducted interviews or granted interviews to members of the press here on the 9th floor. Just so there is no misunderstanding, there are to be no press interviews on the 9th floor conducted by counsel. Reason for that is this is a high security floor. It creates congestion. It's a security problem. It interferes with other courts. It influences other witnesses and jurors on other cases, and there is a standing order against that. The Sheriff's Department has reported to me several instances where the supervising judge's orders have been violated. I'm just putting counsel on notice that the Department 100 will be conducting contempt hearings if this occurs again. So please follow the supervising judge's order in that regard. We do have a first floor press conference area set aside for that purpose. All right, Mr. Darden, you're excused.
Thank you.
All right, Mr. Blazier, Mr. Harmon.
Thank you, Your Honor. We have provided a letter to the prosecution and to the court requesting additional discovery with respect to photographs of some of the evidence. And would you like me to cover those one at a time? Or?
I've read the letter, counsel. I just I understand you're asking for usable, large, seeable photographs.
Correct, Your Honor. The photographs I did not provide to the court. I had Dr. Gerdes fax me a copy of some of the photographs that I referred to in my letter, and I might point out that these photographs contain 8 testing strips in the size of about my picture on my driver's license, so they're simply not usable in the form that we've been given them, and we'd like copies that are the same size as the copies that they will be using in their testimony.
Mr. Harmon. Morning, sir.
Good morning, Your Honor. As we've already seen, nothing's as short or simple as it seems.
Boy, there's an understatement. Certainly.
There are actually 2 categories of items that have been requested. The second category involves proficiency tests, and those copies, better copies will be made of them. The first category, I think, is much more interesting because it really ties in with what the court's struggling with today. At the same time, this court's considering allegations of serious intentional misconduct by the defense in discovery. The defense has the temerity to ask for something that they already have. I think to illustrate the abusive extent of the discovery in the DNA context, I just selected one of the days in the life of Gary Sims at the Department of Justice that directly addresses the nature of the request and why this court has to draw the line at some point. At the same time, the court has recognized that the line has been crossed by the defense in other discovery areas. I just selected October 27th because it seemed to be the longest day for Gary Sims. He started work at about 10 o'clock that morning. He did a full day's work on the DNA test results in this case. And I think the court needs to appreciate, and the court has heard a little bit about DNA, we realize that every test has the possibility of excluding somebody if they deserve to be excluded. If they're not excluded, they will be included. So at the same time that Mr. Sims was analyzing volumes and volumes of evidence on this case, to accept whatever results came out of it. And if Mr. Simpson was going to be excluded and exonerated and shown to be innocent, so be it. That would have been the result that was produced. At the same time that happened, the court had properly instituted some sort of reciprocal visitation by Dr. Blake. And Dr. Blake is the key figure in this discovery request. So Gary Sims worked all day analyzing evidence on this case. And as was the norm, and I think what he did that day is also very interesting. That was the day, coincidentally, that the sock that's the subject of great discussion was examined by the Department of Justice lab. And one of the items that they produced shows that there's no sinister activity about that sock. It's an infrared video that shows that not only, once you know there's blood on the sock and you visually examined it and you've done presumptive tests, not only does that just tell you where some of the stuff is, you need to do infrared photography to see other things once you realize that sock has blood all over it. So that's what Mr. Sims did that day. Prepared that evidence, prepared the videotape, carefully documented things that the documentation takes hours and hours. And then who shows up at 7:45 that night but Dr. Blake? Now, you have to appreciate that Dr. Blake has a business and a life of his own, so he often doesn't show up during the day. He shows up at night, which means Mr. Sims has to work his full day and then on into the night with Dr. Blake. They spent 5 hours going over items, unpackaging items, documenting items, and taking, in many instances, simultaneous photographs of the very same things. Now, those simultaneous photographs are what's at issue in this request. This, as you will remember also, this is the same Dr. Blake that they've hidden behind the attorney-client privilege. This is the same Dr. Blake who has always testified in opposition to the two defense witnesses that we've heard about in this case, Dr. Mullis and Dr. Gertis. These are photographs that were taken of the same items. The defense has made no showing, because they want to hide Dr. Blake, he's never been mentioned in the opening statement, that his photographs of the same items that we've given them what they call inadequate copies are insufficient for his purposes. He's seen them himself. He's taken photographs of them himself. In fact, I think what's ironic about the nature of the request and the invisible Dr. Blake, who's been shielded by the attorney-client privilege, is that in many instances, when Dr. Blake viewed these items, he interpreted them and called those results audibly. And those results, in every instance, concur with the prosecution expert's results. So here we have an invisible witness who has his own photos of the very same items, who's concurred in many instances verbally with the results that the prosecution lab has produced, and they just say, we want you to provide better photos, and they've never demonstrated that there's anything wrong with the photos that they've taken of the very same items. Coincidentally, as the court's aware, the defense has never obtained any of the physical, biological evidence in this case to do any testing of themselves. Dr. Blake can show up there any time with the photos that he has taken of the items that they have requested we provide new photos. He was just there last night. He can show up there anytime to see these things, to compare his photos with the original photos and see if there's any discrepancy. I think we've complied with it. The consumption of time that it takes the DOJ to accommodate Dr. Blake has taken days and days worth of valuable laboratory time from this case and other cases that the Department of Justice services, while, believe it or not, this case goes on rapidly to trial. So the defense simply hasn't shown that they don't have anything. In fact, it is clear, if you look at these voluminous notes, they have their own copies, their own original photos of these very same items. So I think it's time to draw the line. Mr. Cochran wants to go to trial. We want to go to trial too. We want the world to see this. Dr. Blake has seen this. Dr. Blake has seen these things before we've seen them. So I think the court should say, it's time. Mr. Cochran wants to go to trial. We want to go to trial. And there is no basis for any additional burdensome request.
Your Honor, this is a discovery request from our side, not Mr. Harmon's request for Dr. Blake's materials. The photographs that result from these tests are the best evidence of the test results themselves. This is not like we're taking a picture of a piece of physical evidence like a piece of clothing that will then be brought into court. These photographs are what the prosecution will be relying on in giving their interpretations of the test results. There is a lot of controversy in the DQ alpha testing area about the intensity of dots, whether dots are apparent or not. Different experts will look at the same photograph and give you different interpretations of whether there are dots there or not. And it's not our photographs that they're going to be using when they have their experts testify. It's their photographs. That's going to be what they're going to be relying on. They will not be bringing these test strips in because they fade very quickly. That's why the photographs are taken very quickly. So because these are source materials, we certainly are entitled. Their experts are going to rely on them. We're going to be cross-examining them about their pictures, and we're entitled.
Has Dr. Blake had the opportunity to look at these photographs, to look at the test results, make his own photographs of the same thing?
Well, Dr. Blake, it's true, has taken pictures of the testing strips himself, but that is our work product material. We have not made a decision whether Dr. Blake will testify or not. At a point in time where we decide that he will, we'll make available everything that we're required to make. But it's those photographs that they took that they're going to be using. They're not going to be relying on Dr. Blake's photographs. They're going to be relying upon their own, and we're going to be raising significant questions about how they interpret their own photographs. We're entitled to this.
All right. Thank you, counsel.
Can I just briefly respond?
It's not the way it works. All right. Thank you, counsel. All right, counsel, I think the defense has already had the opportunity not only to look at these things in their original state, they've had their opportunity to make their own photographs, compare their own photographs. The defense has been given smaller copies of the original photographs. I think the prosecution has already fully complied. Request is denied.
May I ask for one point of clarification?
Sure.
We haven't been provided with smaller photographs of the DQ alpha testing strips. That related to the last request, which I assume Mr. Harmon said he would comply with. All we've been provided with are Xerox copies, and none of the experts here will tell you that they can make any kind of assessment from Xerox copies of photographs.
Mr. Harmon?
See, this is the point. Dr. Blake has never testified for a defendant in a case like this.
I'm just interested in the photos.
No, but I think it is the point. They want to shield their witnesses, Gerdes and Mullis, from the truth. And the truth is, this is the danger that we tried to point out to them on the motion to quash. They hired the most experienced forensic serologist with PCR DQ alpha. And we had to comply with these burdensome requests to have Gary Sims work until 2 or 3 in the morning at a time when this court was going to try to cut off, or there was a serious concern about cutting off testing. And so now we've done all this. He's taken all these pictures. He has pictures of all these strips. He has pictures of the same things that we have pictures of. They're as real and scientific and sound as the pictures that we have. And now, to further burden us, they want and shield their experts from the truth, that is, the person who took the pictures and saw it and concurs in our results, and they want to force us to give new pictures over. We have satisfied that. He has seen it, and he has his own pictures of it. And they haven't, I would suggest if this court is going to seriously entertain any of this abusive discovery request, that the court put the burden on them to have Dr. Blake come out of hiding and testify that there's some deficiency in his photos. And we'll do it on a photo-by-photo basis. We have wasted valuable day. Well, I mean, I think the legal process calls for something like that, Your Honor.
No.
I know it's real easy to say, well, no, just give it to him, but I don't think the process calls for that, Your Honor.
No, what struck me, Mr. Harmon, is I can see myself having to start another one of these hearings and having to look at all these photos. And
Well, but if the process calls for that, we may have to do that, Your Honor. I think it's real simple to just say give him new copies when I mean, we have shut down the state lab to satisfy Dr. Blake's schedule. You know, if you've ever done lab
Mr.
work.
Harmon, you're just misinterpreting the court's oy vey
Sure.
reaction.
No, I just wanted to make sure that I didn't misinterpret it, Your Honor.
Okay.
But, you know, they haven't shown that they've been deprived of anything, and the only way they can do that is to bring Blake out of hiding and put him up there.
Okay.
And they're not going to do that.
You know, very briefly, when their experts are called, they're going to have the pictures, and we'll be entitled to review them. I'm just trying to save some time here, because we may want to make blow-ups of their pictures, and if we don't get them until the witness testifies, it's going to cause a time delay.
All right. The issue, though, is access, knowledge, disclosure. You've had that. Request is denied. All right. Thank you, counsel. We're in recess. 1:30. When we might be getting an update as to his condition and when he might be able to rejoin us?
No, I have no indication of that at this time, and I probably will not, even by the conclusion of today's proceedings.
What's the status of your position as far as proceeding in his absence?
After we address the court with respect to the discovery matters and the misconduct issues, I think we'll be in a better position to assess that.
All right.
Myself and Mr. Darden would like to address you on these matters, Your Honor. They are numerous, and the court has requested some very specific statements concerning what we desire with respect to each of the items, each of the witnesses, and each of the statements that were improperly made by counsel. I must share with the court that I feel very outraged at counsel's statements earlier this morning concerning his representations that we're trying to prevent him from telling the truth, and that is such a falsehood. If Mr. Cochran were standing up and telling the jurors the truth and had not hidden his witnesses from us willfully in violation of this court's order, we would not be before the court today. An opening statement would have been concluded, and a witness would have been on the witness stand. Unfortunately, because of the nature of this misconduct, which is egregious and flagrant, and not the minor violation that he attempts to represent to this court, he's attempting to sweep it under the rug, claim ignorance, and use Mr. Douglas as a sacrificial lamb, and that is absolutely inappropriate. That counsel should bear the brunt of his own misconduct, which was willful and deliberate and intentional, and is in effect a thumbing of his nose at this court's order. It is, yes, it's couched in nice smiles and ingratiating remarks, but that should not deceive the court, and I'm sure it doesn't. What lies behind it is a willful desire to flout the law, and it violates both the law, it violates us both legally and morally. Legally, it's a violation of 1054 in both spirit and letter of that law. Legally, it's a violation of this court's direct order to counsel, and morally, it's a violation of the jurors' right to the truth. They've been lied to, they've been deceived, they've gotten half-truths from counsel. He has deliberately shown them items that were taken out of context, given them half-truths, giving them actually pieces of statements that led to a diametrically opposed representation of what really was being stated. And counsel is telling the court, oh, that's no big deal. If I mislead them, then the people can come back in closing argument and redress all the wrong. Counsel knows very well that we cannot, because our closing arguments are months down the line, and well, he knows it. Counsel has very carefully and very cynically weighed the risks and the benefits of his misconduct, and he has rightfully assured himself that the risks, if any at all, are far outweighed by the benefit. These jurors have now heard statements and representations of counsel about witnesses that the people were never informed of, that the people could have addressed in their opening statement, and even could have called in their case in chief in order to show the jurors the kind of witnesses that will come forward in a case like this for the sole purpose of gaining celebrity. and Mr. Cochran willfully withheld their names, knowing that what he was going to do was cloak them with a false aura of credibility before this jury and sandbag the people so that we were unaware of them and unable to address them in our opening statement. He made statements concerning witnesses that might never appear because of fear, thereby cloaking a witness with credibility who would never appear probably because of fear of exposure, because they are not telling the truth. Instead, now he's created ideas and notions in the minds of these jurors that there are people out there that will not come forward that would be holding the truth, except for the fear of harassment. And that is not true. There's no evidence of that whatsoever. In fact, we have witnesses coming out of the woodwork who know nothing about the case, claiming to know something just so they can get involved. So counsel has committed numerous acts of misconduct. And for him to turn to us and say we're trying to get into his mind and we're trying to prevent the truth from coming out is outrageous, is disgusting, and is appalling to me as an officer of the court. He knows that is not the case. And to allow that kind of statement to be made, and in essence that is the statement that he made to this jury, is worse than appalling. It is no longer just a fear, Your Honor, that the people's right to a fair trial is going to be damaged. It is a reality. It has been damaged. It's not damaged beyond repair because if certain admonitions are made, certain sanctions are undertaken, and we were able to present the witnesses, the truth will come out because our case is strong. And I'm not worried about our case. What I am worried about is the way these jurors are being manipulated so cynically. They're being told, for example, why didn't the people tell you about this witness? Why didn't the people tell you about that witness? There's a real simple answer for that. They hid those witnesses. How are we supposed to tell the jury about witnesses they never told us about? Witnesses that the court ordered them time and time again to divulge. And willfully they told this court they had no such witnesses. 7 months old these statements are. 7 months old these names are. And only on the very day of his statement to the jury do we find them out, and at the close of the day, no less. Mr. Darden will address that further. I'm going to address the court solely on one aspect at this point, and that is that we are going to ask the court, at first blush, before opening statements are resumed, to admonish the jury, to tell the jury that they are to disregard the statements made by Mr. Cochran concerning the witnesses that were improperly withheld from the prosecution, and to admonish the jury, in effect, that the withholding of that information was misconduct, was in violation of a court order, and in violation of the law that requires both sides to exchange their witnesses and their statements. The other problem is that, Your Honor, I know the defense is arguing, well, we gave them the names of the witnesses. Yes, they gave us no address, they gave us no phone number, and they gave us no statement. Having a blank name on a list of 200 gives us no clue as to what that person might say and whether or not they should be high priority in terms of our investigation. They stand before this court repeatedly saying ridiculous things like, oh, there's 900 lawyers in the DA's office. Yeah, there's also 80,000 cases in the DA's office. Believe it or not, they're not all working on Simpson, nor can they. And there may be 9,000 officers, but guess what? They're not all working on the Simpson investigation either. They can't. Everybody is way overloaded. We have to prioritize. And for them to give us a name with no address, no phone number, and no statement on a list of 200 that contains a lot of bunk that we know they're not going to call is disingenuous and a fraud upon this court. We could not possibly have investigated these people, and to give us these late statements is outrageous misconduct. So we ask that the jury be informed of that fact, that counsel's remarks that relate to the mentioning of those witnesses, either by name or by content of their statement, that they are ordered to disregard them because they were mentioned in derogation of a court order. We are also asking that the court admonish the jury concerning the representations of counsel about witnesses that may not appear due to fear, that there is no such evidence whatsoever. Such remarks made by counsel were improper, and they are stricken from the record, and the jury should be ordered to disregard them. Furthermore, the people will be requesting some additional time to conduct investigation on the numerous witnesses that we have just been given at the close of opening statement day yesterday, as well as the day before. And should the court grant us the continuance in whatever amount of time that it does, we would ask that the court inform the jury as to the reason for the necessity of that continuance, that it was necessitated by counsel's misconduct in failing to turn over the information that it was ordered to turn over by the court. Mr. Darden will address the court on the remaining requests we have pertaining specifically to each witness and to our request to reopen the opening statement.
Mr. Darden.
You want me to do it?
Good afternoon, sir.
Your Honor, good afternoon. Many of the witnesses disclosed to us by the defense the past 2 days are witnesses whose statements had not been given to us on any prior occasion. And the first is Mary Ann Gersh. And as the court will recall, Mr. Cochran told the jury that Mary Ann Gersh saw 4 men running from the scene of the killings on the night of June 12. We have never been given any discovery relative to that witness, that is, until yesterday. And that was given to us after Mr. Cochran already made comments regarding this witness before the jury. Now, this is obviously a material witness, one would think. That is, if one could believe her testimony. Mr. Douglas had this statement in his possession. The defense has had the statement in their possession for several months. Since July. They could have given it to us back in July. They could have given it to us back in December when they were squawking about our discovery problems and while they were asking the court to sanction us. But they didn't do that. They didn't do that throughout that 5-month period in 1994. And in December, when the court began to attempt to set a date for opening statements in this case, the defense didn't turn over this statement. And when they learned the exact day that opening statements would begin, they didn't turn it over. And when Mr. Cochran's opening statement was delayed a day, they didn't turn it over. And when they came into court to begin Mr. Cochran's statement, prior to that statement, that morning, they didn't turn it over. And there's only a few reasons that they didn't. First, they knew that had they turned over this statement this late in the game, the court would have precluded them from utilizing the statement in opening statement. The court would have sanctioned them, as they did us. And they were also aware that had the prosecution known about this particular witness, we would have discredited her. We have only known of this witness 24 hours, and already we know she has 9 lawsuits pending. In the DA's office, in our bad check section, there are $10,000 approximately in bad checks that relate to this person. She has defrauded the J.W. Marriott Corporation of $23,000 by staying in their hotel and not paying for it. And there's much more, much more regarding this witness, but we need time to investigate this witness, Your Honor.
What's your reasonable estimate as how long you need to investigate into the background of Ms. Gerchis, since People versus Jackson at 15 Calap 4th, 1197 at page 1203 indicates what the remedy is: having a meaningful opportunity to rebut or impeach. So what are we speaking of in terms of investigation to adequately be prepared to rebut and or impeach that testimony or that proffer of testimony? That's the issue.
Your Honor, we are concerned that perhaps this witness is not the person she claims to be. She is not the person. She is not the real Mary Ann Gerchis. There is a hint that perhaps she is not that person, and we're concerned about that. And she is such a critical witness, apparently, to the defense, that I believe it would take approximately 30 days to carefully search out the background of this individual.
All right, do you have any other comment as to this witness?
Well, in addition to the sanctions mentioned by Ms. Clark a moment ago, and in addition to a 30-day continuance to carefully investigate this witness's background, I would ask that the court strike any reference to this witness from Mr. Cochran's opening statement and advise the jury that the court is doing so because of Mr. Cochran's willful and flagrant violation of the rules of discovery. In addition, I think that the prejudice that the people have suffered as a result of this flagrant violation, this willful violation, this egregious conduct, that the prejudice is so extreme, I believe that the people should have an opportunity to reopen their opening statement.
Do you have any authority for that proposition?
There is no case law directly on point, Your Honor. However, the court does have discretion in terms of the order of proof. And under 1054.5b, the court has the discretion and the right to order any lawful remedy or legal remedy available to rectify the harm caused us by the defense in this case.
But
To reopen would be only fair.
how does that dovetail to 1093, setting the order of trial in an ordinary criminal matter? Do I have the discretion under 1093 to alter that to allow you to reopen?
I believe so, Your Honor. 1093 says that the proceedings shall proceed in the following order unless otherwise directed by the court. We ask that the court allow us a second opportunity. There is no law against it. It is not our fault that we're in this position. Back in December, you ordered us to provide the defense with discovery. You literally forced us to work 48 hours straight almost to comply with that discovery order. You told us to have discovery to the defense by 5 o'clock on a Friday afternoon, and we worked and we complied. Had we come into court and did what they did and tried to pull something like this, our conduct back in December, which as I recall the court agreed was nothing more than negligent, wasn't nearly as egregious as what has happened in this case. And in response to our mistake, an honest mistake at that, the court gutted the domestic violence evidence in terms of how it could be presented in the case. The court precluded us from calling witnesses in the order we wanted it to call those witnesses, so that now the defense has a hand so deep in our pocket at this point that they're literally dictating the order in which the witnesses will be called by the prosecution. Such sanctions ought to flow both ways, Your Honor.
Well, that's why it's called reciprocal discovery.
That's why it's called reciprocal discovery, and that's why it's a two-way street, and the water should flow both ways and in both directions. We had to do it. I'd like to put my hand in Mr. Cochran's pocket at this point. It's only fair. He created this situation. He didn't have to allow this to happen. The next witness is Dr. Carrie Mullis, an apparent DNA expert on PCR. Prior to the opening statement, we received no statement or report regarding this witness. I have not had a lot of time to search all the documents given the event of yesterday evening.
Was Dr. Mullis on any of the witnesses' lists for the Kelly hearing?
I don't have the Kelly hearing list with me.
Well, one of the things we did with regard to the DNA hearing and the witness list is this. After they allegedly waived their Kelly Fry, we updated our witness list to include the people we intended to call on the DNA issue. This doctor is not on any non-Kelly Fry witness list. And even so, we've never received any report or any statement relative to what this doctor would testify to. We require time to investigate this witness's background. I don't know much about him, but I understand that he is a very controversial figure in the scientific community. We need time to gather transcripts of his prior testimony. We need time to review the scientific literature, to review his background and his training. As the court is aware, that can be very difficult to do. Not anyone, and not just everyone, can perform a task like this as it relates to a scientist such as Dr. Mullis, and it's going to take time. It's going to take about 30 days. We would ask that the court, in addition to the admonition, instruct the jury to disregard any mention of this witness. I would ask the court to allow us to reopen our opening statement. As to Dr. Ron Fishman, Your Honor, we are somewhat acquainted with Dr. Fishman. In fact, I met Dr. Fishman, but unfortunately I didn't have a subpoena on me when I met him. I did, however, cause a subpoena to be issued for Dr. Fishman's appearance in this case. We have been attempting to serve Dr. Fishman and to speak with Dr. Fishman since December 14. We believe that if Dr. Fishman were honest and called to testify and testified honestly, we believe that he would testify that as Nicole Brown left the recital on June 12, he overheard this defendant say, "I'm going to get her, I'm going to teach her a lesson," and words along those lines. And so we have telephoned him, and we have gone to visit him, and we have attempted to serve him. And on January 19, 1995, our investigators were outside Dr. Fishman's home. They met. They told him they were there to serve him with a subpoena, and he turned and he ran. And he ran back inside his house, and he locked the door, and he wouldn't come out. And the investigators placed a subpoena in the mailbox and shouted through the window, "Dr. Fishman, consider yourself served." Well, Dr. Fishman should have been here yesterday, or he should have called the prosecution to be placed on call, and he has done neither. The defense has a statement from Dr. Fishman. We don't have it. We should get it. We should be allowed time to investigate Dr. Fishman. And there are other problems with Dr. Fishman. When the defendant was arrested on June 17, there was a prescription of Xanax, a depressant, in his black bag. The medication apparently was prescribed to Dr. Fishman's mother. I don't know why it's in the defendant's bag, but it's issues like that and the issue of the recital that has to be reviewed and investigated. It's going to take time to deal with the issue of Dr. Ron Fishman, and I would ask for the same sanctions be imposed as it relates to Dr. Fishman, as we requested with regard to Mullis, Gershis, and the other witnesses. Dr. Lenora Walker is a different issue. The defense served us with her CV on January 24, but they have not provided us with any statements or any reports, as they are required to do under the law.
You heard Mr. Cochran's explanation that she had just been retained, was in the process of interviewing the defendant and preparing a report, so I assume it's not there yet.
Okay. Nevertheless, Mr. Cochran represented to the jury that Dr. Walker was going to form a certain conclusion and testify to that conclusion. So apparently Mr. Cochran is aware of what Ms. Walker is going to say, or Dr. Walker, I'm sorry, so what Dr. Walker is going to testify to. But Mr. Cochran also indicated that Dr. Walker had interviewed the defendant and that she had conducted psychological tests. Well, that's discoverable. It's discoverable under Woods versus Superior Court at 25 Calap 4th, 178. That stuff exists. If Mr. Cochran knows enough about Dr. Walker to tell the jury what she's going to testify to, and if testing results exist, if actual tests exist, if there are interviews with the defendant, we have a right to all of that. And that's clear, I believe, in the law. In addition, Mr. Cochran has placed the defendant's mental state and psychological state at issue in this trial and before this jury. And I believe that we have a right to have access to this defendant for psychological testing. And that's an issue we'll take up again in a couple of days. At any event, it will take time to prepare for Dr. Walker. And the court might also recall that when Mr. Cochran was arguing to the jury, that he mentioned that Dr. Walker was watching us on television. So I assume Dr. Walker has some notes, and apparently she communicated her opinions and conclusions to Mr. Cochran, which Mr. Cochran communicated to the jury. We like to have that. We have a right to that. We make the same request with regard to sanctions. Strike it. Tell the jury to ignore it. Tell the jury that Mr. Cochran and the rest of the DREAM team have violated some very, very basic and fundamental discovery rules. The next witness is Michelle Abderram. She was Mr. Simpson's maid, apparently, and according to Mr. Cochran, Nicole once slapped her, Nicole Brown. And I've heard of this incident, and I believe that I've seen reports, some report as it relates to this incident. I know I've read it in the tabloids. And so we are somewhat aware of that witness. But our concern here is that perhaps Mr. Cochran has additional information, additional statements. This is his witness. We have a right to her statement. We have a right to discovery as it relates to this witness. And if the court would order the defense to turn over that statement to us immediately. And I don't believe we have it at this point. Do we?
I think yesterday you were given a statement from June of '94 from this witness. That's on the record at page 11/9/21.
Okay. It's our recollection that that is merely a copy of or is it a copy of a statement the police took? But our concern is this: if the defense has more information, an additional statement, additional notes as they relate to this witness, we would like to have them. And if they don't have them, we'd like them to stand before the court and represent to the court that they don't have them and that they know that they don't have them. If they interviewed this witness, subsequent to our interview of the witness, we want the notes. Okay? And if they interviewed the witness, subsequent to our witness, and if they failed to take notes, we would like the court to order them to reduce the conversation to writing. They have no right to take oral statements, decline to commit them to writing, and then hide them from the prosecution. Whether any additional sanctions should be imposed here, I think, depends on the content of any subsequent statement this witness may have provided the defense. Then there's Joe Stellini. This witness apparently was at the Tryst restaurant. He is a defense witness. We received no statement, no report, no notice, no information regarding Mr. Stellini from the defense prior to the opening statement. We make the same request that the court order the jury to disregard any reference to Mr. Stellini or any reference to anything Mr. Stellini might testify to. He should not be allowed to testify in this case until such time that the witnesses who were included on the defense witness list and whose statement was provided in a timely manner and in a lawful manner, until those people, those witnesses are exhausted. The same sanction you imposed on us, Your Honor, that should apply to him, Mr. Stellini, and it should apply to the rest of them.
You're asking that the court order that any testimony by Mr. Stellini be delayed until the other witnesses on the previous August and December witness lists have been called?
Yes, Your Honor, and I think that should apply to each of the witnesses we were ambushed by yesterday and the day before. Then there's Dr. Batten. We are aware of Dr. Batten. We're aware that he was present on June 17. He appeared before the grand jury. We asked him what happened in Mr. Kardashian's house just before the defendant fled. He told us that the defendant fled as soon as he heard that the police were on their way to arrest him. But we didn't ask Dr. Batten about any testing or the results of any test. We did not ask him about his expert opinion regarding blood or pathology. It was made clear to us that such topics were off limits, that he was a defense expert, and that to inquire in those areas would be to violate the attorney-client privilege, and we honored that. But Mr. Cochran has told us that Dr. Batten will testify that the perpetrator should have been drenched in blood. It would seem to us that Dr. Batten has reviewed certain items and objects. He has perhaps conducted some tests. He has rendered an opinion. We would like those reports. We would like that opinion. And there has to be one, because as I understand the rules in the opening statement, counsel is not allowed to inform the jury of evidence or information that they do not in good faith and reasonably believe will be heard from the witness stand or in open court or received as evidence. If Mr. Cochran or the rest of the dream team have had oral conversations with Dr. Batten regarding his conclusions and opinions, then I would ask the court to order them to reduce these conversations to writing, and that they do it now, immediately. We would ask that the court impose the same sanctions, the sanctions we mentioned earlier. Strike it from the record. Tell the jury to disregard it and ignore it. Tell the jury that the defense, the dream team, America's finest defense attorneys, tell the jury that these lawyers have committed misconduct. They have deceived the court. And that they have violated the basic and fundamental rules of discovery, and that they have impinged upon the people's right to a fair trial. Next is Christian Reichart. He is Faye Resnick's ex-fiancée. She dumped him and he's out to get her. That's fine. I have interviewed Mr. Reichart myself with the use of a court stenographer in the presence of his attorney, Mr. Dominique Rubakova, and we have turned that over to the defense. If there is an additional statement or additional information, we would like to have it. If there were additional conversations not reduced to writing, we would ask that the court order the defense to reduce those conversations to writing. If the defense intends only to rely on the interviews conducted by the prosecution and by the LAPD, then that's fine, but they should stand before the court and inform the court of that. If that's what they're going to do, then there's no surprise necessarily as to Mr. Reichart. But I will say this, and that is that no statement has ever been received from the defense as it relates to Mr. Reichart. In addition, Mr. Reichart is not on the defense witness list. So maybe I jumped the gun on this one. Should strike it. And he should move to the back of the line. And we should be allowed to do as the defense has been allowed to do to us in this case. We should be allowed to let them know when they can call this witness. There's Dr. Barbara Wolf and Dr. Gerdes.
Take them one at a time.
And Dr. Lee. And and we can say the same thing about each of these experts, and that is that we have no reports or statements from these witnesses.
All right, Dr. Wolf, Dr. Gerdes, and
Dr. Lee,
Lee. All right.
I think I've already indicated that we have nothing from Dr. Batten.
I thought you had one report from Dr. Lee already.
Only as pertains to the envelope.
Yes, only as it pertains to the envelope.
Well, that's one.
Well, we heard yesterday that he was the foremost crime scene expert, the best in the world, and he was going to testify about the crime scene. Where's the report? Where's the opinion? We require immediate disclosure of these expert witness reports. We'd ask that the sanctions already mentioned, requested by us as they relate to other witnesses, apply to these witnesses as well. And then there's the envelope, Your Honor. The envelope that Mr. Cochran waved in front of the jury yesterday. The envelope which contains an unspecified knife, as I understand it. I'm not sure exactly what's inside the envelope. I've seen the report. I have not seen the item, but the defense has seen the item. We have no knowledge or information as to where the item came from, how it was recovered, who handled it when and where, how it got there. We know nothing about this item, except what we know from Dr. Lee's report. But the defense knows everything about it, and they apparently intend to introduce it as evidence in this trial. If that is the case, Your Honor, we have a right to know the true circumstances surrounding this particular object. We have a right to know how it was recovered, how the court was contacted. We have a right, I believe, to know all the details surrounding this particular item. And we require immediate discovery as it relates to this item. And I would suggest to the court that the display of that object yesterday was just one of many flagrant violations of this court's rules and orders. This court ordered us to give each side the opportunity to view any exhibits that might be introduced before this jury during opening statement. We didn't get that opportunity. Mr. Cochran just pulled it out, waved it in front of the jury.
That was not exhibited to you during our 2 show and tell sessions.
I've never seen it before, Your Honor.
Thank you.
And I had no knowledge that it was about to be presented to the jury. By the time I saw it, it was in full view of everyone in the room, as I recall. The jury should be ordered to disregard any viewing of that item. They should be ordered not to speculate as to the content of that item or the weight to be attached to it. The jury should be informed that this was a low blow and a cheap shot, and that it is gross misconduct. A serious violation of the court's directives and orders. Mr. Cochran mentioned yesterday that certain witnesses would testify about the defendant playing cards on June 12, and that he suffered some acute attack of arthritis, I believe, some form of arthritis. Well, it is apparent that Mr. Cochran intends to call these witnesses to testify. Well, who are these witnesses? Where are their statements? Where do they live? We don't even have the names. We'd like that information. We require immediate discovery. And the jury should be advised that the defense is up to cheap tricks, and that they're in violation of the court's rules, and that the display, or rather the mention of this card game, the mention of these witnesses, is a flagrant violation of the court's order. The defense also referred to 2 doctors who they say examined the defendant. Who? Where are the reports? Where are the statements? Where are the test results? We didn't get any of that. We didn't get notice.
You have the cite to the record where that is in the transcript. I'm just wondering if you had it. It's all right. Move on, Mr. Darden.
As it relates to those 2 doctors, Your Honor, until we know who they are, how they specialize, or what areas they specialize in, until we get the discovery, it's difficult to seek a particular sanction. But I'll say this, I cannot imagine, I cannot understand why anyone in a case like this, especially given the supposed quality and abilities of these defense lawyers, why anyone would want to hide expert witnesses in a case like this. It's just unfair. It's mind-boggling. Howard Weitzman and Skip Taft were mentioned yesterday. If there's been a conversation with Mr. Weitzman and Mr. Taft, we would like that statement. We would like that conversation reduced to writing. We would like discovery. Any mention of these 2 gentlemen should be stricken. The jury should be admonished. They should be advised to disregard counsel's comments regarding these 2 witnesses. Next.
How do you suggest I deal with the attorney-client issue that it's obviously going to be raised in response?
I don't know whether there is an attorney-client privilege issue in this situation. I don't know what they have to say. We know they have something to say, and whatever Mr. Cochran has said so far certainly ought to operate as some form of waiver as to some or all of any conversations.
Just a few legal issues here.
Just a few.
Go ahead.
Mr. Cochran referred yesterday to an unspecified doctor who would testify that the defendant's cut, one of the cuts, or maybe both, on his left hand is consistent with a knife cut.
I think he said inconsistent.
Okay, inconsistent. I'm sorry. Thank you, gentlemen. Well, we'd like to know who that person is. We'd like to see his report. We'd like to know what qualifications he has to form such an opinion. That should be stricken from the record as well. That's an expert witness. Counsel knew that this person would be testifying. You know, as I sat there yesterday, the day before, watching Mr. Cochran, I noticed that his opening statement, most of it, was typed. If he had time to type it, to type out that opening statement, and it was a very fine opening statement, and I'm always proud of Mr. Cochran whenever I see him in court, Your Honor. I love him. I just don't like to go up against him. But if he had time to type his opening statement, then he had time to turn it over. And I'm disappointed in Mr. Cochran. I'm disappointed that he hasn't turned over that information to us, because just this past weekend, Mr. Cochran and I had a telephone conversation on Sunday evening, and we discussed discovery issues. I discussed with him issues and information which he could not otherwise learn or obtain until the following Monday or Tuesday. And I advised him of these things so that he would know that they were in existence, and so that he wouldn't be surprised. And so I'm surprised to stand here today before the court, Your Honor, and I'm disappointed in Mr. Cochran. I would think that he would return to me the same professional courtesy. And the court will recall that we have been ordered to turn over to the defense, literally within 24 hours or one business day, the name of any potential witness, as well as the statement, as well as the tape of that statement, as well as a transcript, if a transcript exists. These are the rules that the court has set for the prosecution in this case. But no rules have been set apparently for the defense, or if rules have been established for the defense for some reason, and I think I know what that reason is, they don't feel as if they have to live up to those rules or to follow those rules. Apparently they feel that they're above the rules. This conduct is outrageous. Mr. Cochran next described an unspecified gentleman who would testify to having had an affair with Nicole Brown. I don't know who that individual is. I'm confident that it won't be Mr. Marcus Allen, because I traveled to Kansas City and I was present with 3 police detectives when Mr. Allen told us he never had an affair with with Nicole Brown. And so if it is Mr. Marcus Allen, or if it is some other person, we would like the discovery, Your Honor. We'd like to know the identity of that person. Mind you, that we don't think it's going to prove to be relevant in this case anyway, but in the event that it does, counsel has dragged this information in front of the jury in an attempt to sully the reputation of the deceased victim, and that's fine. That happens in court. But we have a right to that information, to the name of that individual, and to that statement, that individual statement. And if they think that they can just sit there and talk to these people on the telephone or in person and not reduce their conversations to notes, or if they think they can reduce their interviews to notes and then not turn them over, well, that's not the law. That's not the law in this state. Now, you can't sandbag the opposition that way. And I understand Mr. Cochran when he stands here and tells us how he's the only one interested in the truth in this case. And I appreciate that. But I would suggest to the court that this conduct, as it relates to the discovery in this case, is completely inconsistent with any desire to determine the truth, or to have the jury determine the truth. And I would like the jury to learn the truth regarding the murders of these 2 people, Your Honor. Win or lose, as long as the truth comes out. But the type of conduct exhibited by the defense these past couple of days and over the past several months, I mean, they had the audacity to stand here and demand that you sanction us, all the while knowing that they had statements from material witnesses that they took 4, 5, and 6 months prior. And they knew they had them, and they knew they hadn't turned them over. And they stood here and asked you to sanction us. The gall. The court should impress upon the defense that the rules apply to them. It doesn't just apply to the poor civil servant lawyers over here on the other side. It applies to the dream team too, and to the dream defendant. It isn't fair. What they've done in this courtroom the past couple of days is not fair. I have never, ever seen anything like this. Mr. Cochran next made reference to tire tracks and another trail of footprints.
Let's take those one at a time.
Okay. It is apparent to us, based on his comments yesterday, that they have an expert. And maybe that expert is Dr. Lee, or maybe it's some other person who has reviewed this issue on behalf of the defense. Whoever that person is, Mr. Cochran has indicated that they will probably be testifying in this trial, or that they will be. We have a right to know who they are. We have a right to any statements they've made, any tests that they've conducted, any conclusions that they've drawn. We have that right. And it's just, this isn't just some right that just came to us the Monday or on January 1, 1995. This is a right we've had for years and years and years. And Mr. Douglas and Mr. Ullman and Mr. Cochran have stood before the court and told the court that we understand, this is what they said, we understand our responsibilities under the rules and laws of discovery. And yet they've chosen to ignore those rules and those laws and the court's order. If they have experts or reports or studies or anything not given to them by us, any photographs, anything relied upon by the expert they intend to call, we have a right to have that. And this expert, if there is such an expert, should not be allowed to testify in these proceedings until the end, Your Honor. Until the end, and the jury should be admonished, instructed to disregard Mr. Cochran's comments regarding this witness in his opening statement.
So you have the same comment as far as the tire tracks and the footprints?
Yes, Your Honor. Next, Mr. Cochran mentioned Dino, and I apologize if I mispronounced the last name. It's Buccola, B-U-C-C-O-L-A. And this relates to his observations at the Red Onion, an incident which was described in our domestic violence motion.
Is this one of the individuals in the car?
Yes. We received a statement, I believe yesterday, regarding this gentleman.
That was not one of the statements
Was it?
yesterday. It's not on my list of items turned over. Mr. Douglas?
Is that the court? Okay. That's right. Yes, as they were running to the elevator. Here, have some more discovery. They gave us 2 reports just that way yesterday.
That's not correct, Your Honor.
Well,
Wait your turn, Mr. Douglas.
we'll get there. Mr. Darden, all right, what is the date on this witness statement?
Do you have it here? I believe it is, well, why don't the court inquire Mr. Douglas, if you don't mind? I don't have it immediately available.
Okay. So but you have now a statement from Mr. Buccola
Yes,
regarding that incident?
yes.
All right.
I believe it's dated, if you would inquire?
No, I'll find out soon enough.
Okay, well, it's about January 25 or something like that.
Okay.
And it raises a significant issue, I think. As we proceeded with our investigation, we interviewed witnesses on January 1 and January 2 and January 3 and dates like that, and January 10. And as we turned those witnesses over to the defense within 1 business day, and in compliance with the court's order, we were nevertheless precluded from mentioning those witnesses in opening statement, and we were precluded from calling those witnesses until the end of the prosecution's case. And it was no fault of ours that we discovered these witnesses on January 1 and turned them over the next day. It was no fault of ours. And still, we had to suffer some form of sanction. We suffered a sanction for being diligent. They've given us this gentleman's statement taken just a few days ago. He should move to the back, just like ours.
Now, I don't recall this person being mentioned in opening statement or any issue.
Okay, then he should just be required to move to the back then. And Mr. Cochran should be precluded from mentioning him in the event he intends to.
Certainly. Madam Reporter, how are you doing? All right, I'm going to go another 15.
We received a number of statements on January 25, Your Honor. Mr. Bacola's statement was one. We received a statement regarding Mr. Jason Wood, and we will seek no sanction as it relates to Jason Wood. We interviewed him. We're acquainted with him, and the report we received was consistent with what we already know, and so we will seek no sanction. But we will ask the court, however, to ask the defense, do they have information in addition? Next, Your Honor, there's Ronald Taylor. We received his statement on January 25th. He was on their August 31 witness list. However, they waited until January 25th to give us a statement. There was Paul Solenshine, S-O-L-E-N-S-H-I-N-E.
Hold on. All right, Paul Sonnenschein, the Rubens employee.
Your Honor, I stand corrected. We did receive an earlier statement on Taylor. Don't talk to me, okay? We did not receive a statement on Paul Solenshine until January 25. As I indicated, he was on the August 31 witness list. However, no statement was provided. The same applies to Rosita Ruban, R-H-E-U-B-A-N. We require time to investigate the content of their statements and determine if they have information relevant to these proceedings. They should not be allowed to call these witnesses.
Are the people intending on presenting any of the items seized from Mr. Cowling's automobile?
We have not yet made that decision, Your Honor. They should be precluded from calling Mr. Solenshine and Ms. Ruban until the conclusion of their case and until we have been given a reasonable opportunity to investigate their backgrounds and the content of any statement they might give. Next, there is the statement of Tony Parker given to us on January 25. We had no prior discovery regarding this witness. We require additional time to investigate the content of his statement as well as his background. We were given a statement, or rather Kevin Whalen's statement, and he claimed to have gotten the defendant's autograph on June 12, 1994 at 11:20. You would think that he might be a material witness to the defense, and I'm sure they saw it that way. And he was on their August 31 witness list, but they didn't turn that statement over to us until January 25th, 6 months after the homicides. Yesterday, Mr. Cochran mentioned We'll strike that. On the January 25, we received a statement from Narendran Singh regarding the possibility of a tape of some kind at the Mezzaluna restaurant. This person was on the August 31 witness list. We received that person's statement on January 25, 1995. And next is Alex Castillo. He has some information regarding a beeper or pager. And he was on the defense August 31 witness list. But it was not until January 25, 1995, that we received a statement or a report. Can I have one moment, John?
Certainly.
And as the attorneys confer here, they do appear to be moving toward the end of a laundry list of what the prosecution calls deceit, failure by the defense to comply with discovery rules, and we will move back into court.
We advise the court that the defense was playing fast and loose with the discovery rules, with the evidence. Each time a member of the Dream Team stepped to the podium and advised the court to what they thought the law required. They advised the court that they had no discovery, they had no reports, or they didn't intend to call a witness, or that they had no duty to turn over relevant and material information, statements from material witnesses that they knew from day one they would want to call in this trial. And they did that time and time again. Mr. Douglas did it just last week on January 20. And the court may recall, and this is at volume 73, at page 11319, where Mr. Douglas informed the court, "Certainly, Your Honor, the court understands our obligations under the Discovery Act, and certainly, Your Honor, with this fine collection of lawyers, we understand our obligations under the Discovery Act." And I think their understanding, Your Honor, was probably correct, and that is that they had a duty to turn over the statements of these material witnesses. And I think they understood that. I think the law is pretty clear there. I think Mr. Ullman stated it rather succinctly and clearly when he said, in circumstances like these where trial has already begun, each party has a duty to turn over to the other party discoverable material immediately. And Mr. Ullman said to the court, "Your Honor, immediate means immediate. It means now. It means soon as possible." And that, as I recall, was the court's understanding of the term. Well, we've been in trial since September, as I understand it. Well, it is that section of the discovery rules that applies to these defendants, to this defendant and these defense attorneys. They should have turned over this information to us immediately. But they didn't. They wanted to sandbag us. Had they turned the information over to us last week or at Christmas or on December 14, as we did, the court will recall that on December 14, we turned over discovery to the defense, and you had to pull them off the ceiling. It's 6 weeks later now. The sanctions the court imposed on us back on December 23rd and earlier are still in effect. They've had 6 weeks to conduct an investigation, and in that 6 weeks, I don't know what they did in terms of an investigation, but in that 6 weeks, they certainly had an opportunity to think about the issue of discovery. I mean, they filed a 40-page brief on the subject. They argued it to the court day after day. They understand the law. They understand the rules. They know that they are not allowed to turn over discovery to us after Mr. Cochran has mentioned the content of that discovery before the jury already. They know that they have a duty to turn over information to us immediately. But they didn't do that. They didn't do it last year. They didn't do it last month. They didn't even do it the morning before Mr. Cochran began his opening statement. And that's outrageous. That's outrageous. And they didn't do it because they knew that had they done it, you would not have allowed Mr. Cochran to poison the minds of these jurors with hearsay on top of hearsay, with the content of statements given him by witnesses who are completely unreliable, and whose background I am sure that if Mr. Cochran knew or was aware, he would not have even mentioned. When the voters in this state passed Proposition 115, there was a clear mandate, and that mandate was no more sandbagging, no more sleazy trial tactics, no more abuse of the process or of the system or of the courts. As the court already alluded to earlier, discovery became a two-way street. I don't know why the Dream Team can't seem to understand that or grasp that, or why they don't want to follow the rules. I understand that they have a celebrity client, and I understand this is allegedly the biggest murder case ever, but the rules don't stop just for this case. The rules apply to this case. Had we done what they did, I shudder to think what the court would have done to our case. Because even despite our innocent and negligent mistakes in terms of discovery, you've gutted our case to some extent. You've dismantled it in many respects.
Rearranged it.
You rearranged it all right. And I don't think that's fair. But the bell has already been rung, Your Honor, and the shot has already been fired. And once the shot's fired, as Mr. DeBlanc stated last night on television, once the bullet's out the gun, you can't get it back.
You had time to watch television last night?
I heard about it. I heard about it, Your Honor. I've missed the entire NBA season up to this point, and I am upset about that. But the people have a right to a fair trial just like Mr. Simpson does. And we have a right to play on a level field. And that field is supposed to be level and supposed to be balanced. Well, there is a terrible imbalance now. And this imbalance is brought about by the Dream Team's refusal. And there's intentional and willful disregard for some very basic and fundamental rules of discovery. This is their fault that the field is no longer a level playing field. It's their fault that things are out of balance. And I want the court to understand that it's not, so much of Mr. Cochran's opening statement the other day. I mean, he did what I figured he would do. He's a good lawyer. They say he's the best. He's a friend of mine. I'm proud to have him as a friend of mine, but I'm disappointed in him. But I want Mr. Cochran to know, Mr. Simpson too, to know that we're not just here playing games either. We may just be civil servants and blue-collar lawyers, Your Honor, but we intend to win this case. But the only way we're going to win, and the only way we can fully and fairly participate in this process, would be if the court rectified this imbalance. And I believe the court must, because this problem and this issue, it's more than just an affront to the prosecution. It is an attack on the integrity of this court. They violated your rules, not just mine, not just the legislature's, not just the rules of court, but your rules, Your Honor.
The legislature had nothing to do with this, Mr. Dard. Do you know that?
Thanks for pointing that out to me, Your Honor. We would ask that the court admonish the jury, and we would ask as well that we be granted a brief continuance so that we can fully assess what has happened, so that we can investigate the backgrounds and the information provided to us in court these past couple of days. And we think we have a right to that. I think we have an absolute right to that. The code section speaks to the remedies the court can provide in a situation like this, where there exists such a flagrant violation. of the code. And we would ask that the court allow us to reopen our opening statement. And to correct the imbalance, to make the playing field level again. I'm sure Mr. Simpson didn't play on lopsided playing fields back when he was in the NFL, you know. I mean, there were 11 guys on each side. It was fair. Of course, they had Mr. Simpson on their team. I just want a fair shot. We just want a fair trial. This ain't all about just winning and losing. It's about fairness. It's about justice. Starting to sound like Cochran, aren't I? Although there is little case law, no case law on the issue of reopening an opening statement, there is case law addressing the issue of reopening closing arguments.
I'm familiar with those cases. I was looking for one that dealt with opening statements.
So was I, and I was looking for that case until 2:15 this morning, Your Honor.
I know all about reopening argument, counsel.
And I would say this as
Let
well.
me rephrase that.
Okay.
I know something about it.
And I know the court knows that the court has discretion in terms of the order of proof, in terms of the order of the processes here in this case. And I would say something else, Your Honor, about what has happened here. We have something in the state of California called the Rules of Professional Conduct. It's ethics. And I'm not here to accuse my distinguished colleagues of being unethical. But I would like to point out, if I may, to the court, that there exists in the State Bar Rules of Professional Conduct, Section 5220, entitled Suppression of Evidence. And that section indicates that a member of the bar shall not suppress evidence, that the member or the member's client has a legal obligation to reveal or to produce. And there's also Section 5-200, subsection B, which states that members of the bar shall not seek to mislead the judge or the trier of fact. What has happened here over these past months has been misleading. We've been misled. I believe the court has been misled. There's a clear indication that they have suppressed evidence, information that they should have turned over to the prosecution. And I'm not saying, hey, you should call the state bar or something like that. I'm not saying that. These are my friends. But I do think that they have committed a flagrant violation of the discovery rules, and they have caused the people to suffer extreme prejudice. How are you going to unring the bell? How are you going to get back the bullet once it's already fired? They brought this on themselves. We didn't do it to them. We'd like a fair trial, a fair shot at presenting to this jury the truth. We're not getting that. And we won't get it as long as they are allowed to play fast and loose with the rules. May I have one moment?
Mr. Jard, maybe this would be an appropriate time to take a court reporter recess. All right, we'll take 15.